Good day and welcome to a new episode of Strictly Legal on WESN Content Capital. I am your host, Rondell, Donawa, attorney at law. Once again, I'm happy to be alive. I'm happy to bring the law and you. Of course, you can stream us on WESN platforms as well as traditional media and our podcast, Strictly Legal with Rondell Donawa. Today, we are going to go into the medical legal type of program today, where we are going to speak about the legal implications of medical malpractice, patient rights and responsibility. And I have none other than Mr. Robert Otway, who is a very experienced attorney at law, having been called to the bar in Trinidad and Tobago on July 1977. I believe he started practicing law in 1977. Of course, he has been partner in Lex Caribbean, Hammersmith and Co., where he headed the civil litigation department. In 95, he would have set up his own practice, which he has been carrying under the name of Otway and Associates up to today, continuing the work of medical legal claims, which includes, including against doctors and private institutions, and also representing public hospitals through the relevant regional health authorities. Mr. Otway continues to work, although he's currently, as he said, in semi-retirement in Mexico. So that's why we will be joining him via Zoom today. And of course, I'm very honored to have him as a guest specifically to speak about the whole issue of medical negligence. So I will bring him on now. Good day. Well, it's still morning. It's about 2 hours behind, as you said. Mr. Otway, how are you doing?
Fine, thank you, Rondell. Pleasure to be here. One slight correction. The first name is Robin.
Robin. Why am I saying Robert? Robin.
Batman,
Robin, yes. My apologies. I'm so sorry. Yes,
That's
Robin.
all right.
Robin Otway. Yes. So how are you?
I'm going fine, thanks. Enjoying life in Mexico.
Nice, lovely. Yeah, the weather looks lovely over there. At
It's
least from
hot
what I'm
right now.
seeing.
It gets really hot, like 44 degrees yesterday.
Oh wow, yeah, that's a lot. That's a lot. That calls for AC weather. But in any but in any event, we are speaking about medical malpractice, particularly in our jurisdiction, Trinidad and Tobago, as well. I mean, of course, this type of law, area of law, is also widely known in the Caribbean and the world. So let's just get into what are the elements, or rather, the legal definition of medical negligence.
Could I first start with the general definition of negligence,
Sure.
which is a very wide application? Could apply to a motor car accident, somebody falling in a hole along a street and claiming that a borough council or governmental authority is responsible, somebody hitting another person. It's very wide ranging, and it's defined as the failure, this is negligence generally, to exercise the care towards others which a reasonable or prudent person would do in the same or similar circumstances, and it can consist of acts or omissions when there's a duty, where there is some duty to act, for example, to help a victim of your previous conduct. Coming now specifically to the medical legal aspect, how negligence is seen in medical negligence cases. And there are two fundamental questions to be asked there. Now, we don't have anything like what you might call a Bill of Rights for patients who may want to bring a medical legal action. So the definitions come from what we lawyers call the common law, that is, precedents of judgments delivered by the courts and which have been accepted over the years. And this one is very much the definition that is followed generally in the Commonwealth. It comes out of an English case. And the first question is, has the doctor practiced up to a standard expected of a reasonably competent medical practitioner in the particular field? The standard expected of a reasonably competent medical practitioner in the particular field. Now, I'm going to come back to the words "the particular field" in a bit.
Indeed.
The second fundamental test, when a doctor follows a particular practice, and this can apply, I think, in particular to surgery, where a particular operation is being carried out in a particular way. So the second fundamental question in terms of the practice, how the doctor does his work, has the doctor adopted a practice accepted as proper by a responsible body of medical opinion in the same field. So we come back to the word field, particular field earlier, same field. So the question there, in terms of the particular field, if an example, if a general practitioner were to undertake something that was considered a specialist task, he would be judged by the standards of this specialty. If he's unable to meet those standards, then he will be held negligent for undertaking work beyond his competence. Do you think Rondell have expressed that in a way that's not too sort of legalese?
Indeed. So basically we are saying that, of course, the standard of proof is what is reasonable. That is, in terms of the doctor's practice. Now, who decides what is reasonable in terms of how the doctor or how the medical institution deals with patients?
Medical legal field, it would be the courts. The courts would decide. A case in medical negligence is prepared in a particular way. It's a complex area of litigation. There are obvious cases at times. For example, there have been cases where a patient goes into surgery to have one limb, or say one leg amputated, and the doctor cuts off the wrong leg, he amputates the wrong limb. Now that's open and shut, right? Once the records are clear that the injured limb was the one to be removed and it wasn't, then that should be open and shut. But very few cases are open and shut in the medical legal field, and it boils down to the expert witness as the cases get more complicated.
Of course, and the situation that we have at hand, I mean, there's a lot of different types of cases where some form of negligence would have occurred, perceivably occurred on the doctor's part. Now, in terms of those type of cases, and of course the patient's rights, right? You know, at the end of the day, as you said, there's a standard of proof in terms of what is reasonable in your area of practice. More particularly when it comes to negligence in terms of birth of a child, and a lot of times mothers died during delivery, and then they blame the hospital for not having the proper trained personnel, or rather the equipment to deal with such complications. How does that legal challenge occur there?
Now, this is in terms of available equipment?
I mean, both in terms of, I mean, whether or not there was due care and attention in the delivery, or or in terms of a cause of action of there not being the resources that is available.
The obstetric, the gynecological field is one where there's quite a bit of litigation. One of the more common cases, which of course involves very severe damage, is cerebral palsy, a baby born with cerebral palsy, which could come out because of difficulties experienced in, as we call it, it's medically referred to, the birth canal, the process of actually the baby emerging. Sometimes damage is done, cerebral damage to the brain, and if it's very severe, the child can be born with cerebral palsy. There's another well-traveled ground of what is called pre-eclampsia, where the mother is detected or reports to her doctor, her gynecologist, that she's suffering with high blood pressure. And that requires that particular care be taken, because it could lead to both mother and child, or one or the other, or both dying on the table as delivery is taking place. So there are particular issues with gynecologists. Have I answered your question, Rondell?
Indeed.
Availability of equipment, yes, the basic equipment. I mean, delivery is not, as it were, a process that normally requires sophisticated equipment. You're checking the pulse, and you're taking what they call the vital signs: pulse, blood pressure, breathing. The patient has to be monitored. There are cases, of course, with surgery generally, and in delivery of children, where it's done by a cesarean, where the patient is under an anesthetic. And anesthetists are also quite commonly sued. their job is they have a very, their activity, the kind of job they carry out is very demanding and intense. They have to keep a careful look at what's happening on the operating table. How is the patient breathing? Monitor the vital signs. Are there any signs of distress? And take appropriate action. And they are also responsible for post-operative care after the operation and the immediate period following it. And the test law is basically 24 hours to make sure that the patient is properly monitored. If there's the need for painkillers, that the right amount is given, and the general care to be taken by the nursing staff if it's in, well, it would normally be in a hospital or private clinic. So he has a particular responsibility. And generally, when a patient dies within 24 hours of an operation, it is, at first glance, it's what they call the first suspicion question to be answered is this an anesthetic death, is the term used in the case law, the cases that are precedents. So the anesthetist is one to take particular care. The surgeons are exposed. I think surgeons generally, but orthopedic, bone specialists, sometimes a person comes in with serious bone injury, say from an accident, and the orthopedic surgeon has to take particular care as to how he deals with this person. So surgery is a particular area generally where there's quite a bit of litigation. Gynecology, sometimes as simple as, let's say a man goes for a vasectomy and it doesn't work. There are cases that suggest that the doctor might be responsible for raising the child, taking care of the expenses. Of course, we'll come at some point whenever you're ready to the issue of informed consent.
And actually,
operation is guaranteed to be fruitful.
I am happy that you did, that you actually raised that issue, because that will be my next question in terms of understanding what is informed consent with respect to a patient consenting to one, this medical procedure, two, the fact that there are risks involved, and whether that risk will absolve the doctor and or the medical institution from liability should something go wrong.
Yeah, that's an area that's developed more recently, and when we say more recently in law, that could be going on to 100 years. So I don't think it's as long as that. The doctor has a duty to obtain an informed consent, and it must be to safeguard his or her position in writing, signed by the patient, and he must warn the patient of any reasonable risk of the procedure. Sometimes there could be in surgery nerve damage, and there are various risks. There are risks involved in anesthetic. Some people are more susceptible, they don't react well to the anesthetic. They may have heart issues, they may have breathing, respiratory issues. And so you want, for example, a case where a person has a steel rod, a scoliosis operation, higher up in the spine, the neck may not be very flexible, and this may cause issues with breathing. So, as I say, the anesthetist has particular responsibilities. The surgeon, too, must make sure the patient is warned. Some risks are very far-fetched. You wouldn't expect it, but the normal and risks to be reasonably expected of a particular procedure, the patient must be informed of those and therefore give an informed consent. Yes, doctor, I understand that this procedure has some risks. I agree to undergo those risks. A person may have cancer, dying of cancer, there are risks. But of course, if the operation is not carried out, the person may die fairly quickly.
But
So,
even if there are risks involved, does that now qualify, or rather, does that now mean that one cannot sue or take action against a hospital for whatever negligence that may come with that risk? Because yes, you are taking a risk, but sometimes there may be something that went wrong that is not the patient's, that has nothing to do with the risk involved, but more to do with malpractice.
Yes. The informed consent is relevant, legally speaking, where one of the risks that one could reasonably expect, affects the patient. There are other issues that could go wrong. The operation is carried out in a way where the patient bleeds out, bleeds to death. It leads to complications like that. And post-operatively, the anesthetist has his responsibilities, and the nurses, the private hospital or government hospital, they have a duty to ensure that the patient is properly monitored.
And that's obviously their duty at the end of the day. So the duty is sort of like twofold, right? The patient's responsibility, and let's get to what are the specific responsibilities that patients have in preventing this type of negligence. Let's look at the patient's responsibility. Now we've spoken about the healthcare professional responsibility, but of course there has to be some contributory, I wouldn't even say negligence, but in terms of just getting what the patient has to do prior to any procedure, or even if there wasn't a planned procedure, how can the patient, basically prevent?
The patient has a responsibility in looking after his or her own health to give a full history, to paint the full picture health-wise of the patient. So the patient must say, well, look, I have an issue with high blood pressure, or I have an issue with asthma, or I have scoliosis. Well, the doctor should be able to see that. The patient has to make sure that the doctor is fully in the picture by giving the patient's full history or story health-wise.
And let's say, for instance, the patient is not aware that they had some form of medical history.
Well, yeah. If they don't know, you can't blame the patient. The doctor, too, has a duty to ask questions. For example, come back to the anesthetist. The anesthetist has to ask questions. Do you have any problems with your heart? Do you have asthma? Do you have any issues? He or she, the anesthetist, the consultant anesthetist, a specialist, knows where the areas of risk lie, and he needs to explore and ask the patient particular questions.
And of course, that will come also with having tests done to check and see whether or not there are any sort of illnesses that the patient may have that they are unaware of.
Yes. Particular tests, doctors know ought to know they have particular tests they must do before an operation. Check the vital signs, the pressure, and so on, to make sure the patient is in reasonably good health. And of course, when you're undergoing an anesthetic, you should not eat for a certain time. I think it's 24 hours, or could it be 12 hours? I'm not 100% there, before the operation. So it requires personal discipline. Yeah?
Yes. Now we're looking at the issue of proving medical negligence, obviously. If someone is to take a claim, obviously the first step is what is the standard of proof.
Yes.
We mentioned as well witnesses, expert witnesses. Those are medical professionals who are experts in a particular medical area that they are dealing with. Now let's talk more about the expert witnesses aspect. Of course, I know I was having a conversation with you, and this is well known. I mean, especially here, we are a small society, and generally, medical practitioners stick together in terms of their profession. Now, how sure can one be in terms of the litigant that this particular expert will not be biased, or that they can actually find an expert that will testify against a particular doctor?
Yes, that's a big issue in a relatively small community. I have seen cases where doctors Trinidad and Tobago doctors testify against their colleagues. There may be cases where the doctor feels that this is an outrageous, something outrageous has been done and it's caused the patient particular difficulties. But there is the tendency for what you might call the closing of ranks. The doctors stick together. It isn't always so. I mentioned obvious cases, right? The wrong limb is amputated. You don't need an expert normally to say that, to come and testify to that. There are cases which are immediately obvious, and there are cases which may become obvious. One of the causes of action, the types of situations that can can produce litigation is what in the surgical field they call retained objects. An operation is carried out and somehow something is left inside the patient. The surgeon has a duty to ensure that everything he puts inside, which could be cotton pads, which could be clamps, I think a case where a scalpel was found inside the patient. That's pretty extreme, but the surgeon has to ensure that everything that was put inside the body during surgery is removed. And if it is not, and problems develop, in that situation, it may not be immediately obvious, but it may become obvious over time. The patient has complaints, they're feeling unwell, and so on. And so the patient then has to make sure they are properly checked out, especially if an operation has been done. Make sure that the next doctor they may go to could be found negligent in not getting the history about the operation. The patient has to tell about it, talk about it. The doctor has to ask what was the procedure and so on. So with retained objects, it may become obvious later on after inspections are done. And if there's a retained object, then it should be an open and shut case. You know, you don't need an expert surgeon to come and say, well, they shouldn't have left a scalpel in you, or they shouldn't have left a clamp or cotton pad in you. That's pretty open and shut. But those cases are few and far between. In my experience, I've never had, yes, I dealt with one with a retained object that was settled. So in the general run of cases, you need an expert witness, somebody who has expertise in the particular field. You're dealing with surgery, a consultant surgeon, an experienced surgeon who's a specialist, anesthetist, consultant with bone injuries, consultant orthopedic surgeon, and so on. So you need to source a witness. Now, if a case is being prepared responsibly, you need to get advice before you file the case in the court to set out the claim, to set out what we call the particulars of negligence. Where are you saying the doctor in question went wrong? What did he do wrong? In the case of an anesthetist, it may be he overprescribed the pain-killing drugs to a patient with a history of respiratory breathing issues. So you need expert help, and that can be difficult to get and expensive. In recent times, many lawyers look abroad, and they are, say in England, they are retired or semi-retired doctors who, as part of their work, they go to court and testify as expert witnesses, but they are expensive. And so before you start, of course, they're billing you in pounds sterling, before you start and file a case, it is best to get expert assistance and experts' input to define where the doctor against whom the case is to be brought went wrong, so you can properly set out, or as we say, plead, set out the case, the allegations of negligence, the specific allegations.
And
okay?
Of course, it boils down to cost, and this is one of the main reasons why you find that there are a lot of issues or a lot of malpractice that may have occurred, and persons just can't afford an expert, because obviously we require an experienced attorney, as well as getting an opinion prior to know the strengths of your case. And obviously this can only be done if you have the funds available. And you know, and this is why, as I said, you know, the poor are always at a disadvantage, particularly when it comes to these medical cases, especially in the public health sector. I am uncertain whether legal aid is one that whether one can qualify for legal aid, or whether legal aid actually pursues or welcomes such negligence cases as part of their remit.
As far as I know, they do. The legal aid is obtained by proving, you know, the legal aid authority, aid and advisory authority investigates your means. They ask you what are your means, what job you do, what income you have, what property you own, and then they will normally do their investigations and determine whether the particular client, the applicant for legal aid, qualifies.
And besides the qualification, now it's whether or not you would have an attorney on the panel that is willing or that is competent to,
Then
take
it's
over this type of matter.
yeah.
You know.
Normally, in cases, especially in medical legal area, is normally very complex. It's very
Indeed.
challenging, and for me, very exciting work. But in terms of the human aspect of it, it can be very, very emotionally challenging, very sad. A child has died in an operation. A baby is born with cerebral palsy. That's heavy-duty emotional stuff.
Yep.
And that tests me. That does test me. As much as I find the work exciting, but there's that human aspect to the work. Hope I haven't gone off track there, Rondell. You were asking about legal aid authority. Now, normally, yes,
That's fine.
the medical legal area is complex, and normally you would have an instructing lawyer, an instructing attorney who deals with the client, who takes instructions, and he would go to a counsel, a court specialist, somebody who will argue the case in court. And the legal aid and advisory authority in a medical legal case, and in most cases, should be prepared to deal with that, the costs of that. There may be limitations in terms of which lawyers of the expert counsel may make themselves available at a reasonable fee. So yes,
it's still something that there are disadvantages when it comes to litigants or prospective litigants who have suffered at the hands of medical institutions. If we are to look at in terms of compensation, damages, what type of damages someone seeks, a patient, someone who seeks, because it could be a patient or it could be an estate, because obviously patients could be, if they are deceased, then it becomes their estate suing, taking action. But so what type of damages can one seek?
Now, in negligence cases generally, and I gave the definition of negligence early on. Negligence is a very wide-ranging term in terms of the kinds of litigation that it may produce. There's a principle, and I'll use a Latin expression, restitutio in integrum. And what that means in lay language is the court will try to will make an award of damages, which will, as far as possible, as far as money can do so, will put the patient back in the position he was before the wrong was committed, the act that was complained of, in respect of which a patient may succeed in his litigation. And that could include having a corrective procedure done. A patient where the operation has gone wrong may have to be hospitalized for a long period, may have to get specialist medical attention. There are cases where patients go into a coma and stay that way for a long time and may die after sometimes years. And so doctors have to come home. Ambulances, sometimes when there are emergencies, have to be used to take the patient in a coma to a clinic. So all of that is what, so far as those expenses, those costs have been incurred, you've had that money spent before the trial takes place, it's called special damages, actual monetary sums spent.
Yeah.
So you have special damages, money spent. You have general damages, which could include pain, suffering, and loss of amenity. So a younger person, let's say one who's very active, a professional basketball player, a lawyer who, because of an operation, is disabled in terms of his mental capacity or physical capacity, professional. That's why the somewhat cynical expression, cheaper to kill than to maim. Sadly, it's not a joke, but it's if you have somebody who's living with a disability, say under a coma, or who's living and they can't perform their normal duties, a lawyer badly injured in an accident, doctor, accountant, any other professional, anybody with a high-earning job, financial person and so on, their future losses. So had they been able to continue working, they would have got future earnings. They have future losses, medical expenses. The court has to go try to make an award there. And sometimes it's very difficult. It's almost like an actuarial exercise. Pain, suffering, and loss of amenity looks at what the patient has endured. He may be in agony, may suffer daily pain because an operation, let's say, some form of medical treatment has gone wrong. So he is compensated. And in that situation, the court will look at the case law, the precedents.
The precedent,
The
of course.
people of this age, with a young person, they have a much longer life ahead of them, or if they die in an operation, let's say a university graduate just starting his career, he has a long period ahead and may be expected to give support to his family. He may have a wife, children. They're deprived of his love and affection and attention and his support. There's what we call under pain, suffering, loss of amenity. One aspect of that is loss of enjoyment of life.
And Robin, sorry.
Yeah.
Indeed, can we, let's take a pin there. We have to take a break and we'll be right back speaking just about the pain, suffering, loss of amenity so we can get a general overview of the damages. You're watching Strictly Legal. We'll be right back. And we are back. You're watching WESN, Strictly Legal. We are speaking to Mr. Robin Otway, attorney at law of Otway and Associates. We are speaking about medical negligence, more particularly patients' rights, what are the institution's responsibility. And just before the break, we were chatting, Robin, about the different types of damages. So we dealt with special damages, which means the monetary aspect of care, treatment, whether it is after, well, mostly after injuries, as well as if, for instance, that also includes whatever future loss, correct? That may be as a result of the particular issue or the particular damage. Now, we're dealing with pain, suffering, loss of amenity. I note that you would have started or stopped there, so let's continue.
I was talking about loss of amenity,
yes.
And in particular, a subset, as it were, a subsection in there of loss of enjoyment of life. If I'm a very active person, a professional footballer or athlete, as of course I'm the most active, and I find I've gone in for orthopedic surgery to correct a condition, let's say my knee, something wrong with my leg, and I come out much worse and I'm now unable to pursue my profession, or even if I'm an amateur, I can't go and run every afternoon or kick ball, play tennis, whatever it is. So the loss of enjoyment is more acute, is more severe, and would cause a higher award from the court, always in these areas based on precedents, cases that have gone before, decided, and the higher the level of legal authority, the better, the stronger the arguments would be. And when I say the higher, you have the High Court, we have a Court of Appeal, and the highest court is the Privy Council. So as a lawyer preparing a case like that, you look for where you can get the highest level of previous decisions coming out, say, of the Court of Appeal, if you're in the High Court, arguing your case in the High Court, or the Privy Council is the most strongest. So you look for cases like that and examples where, let's say, a very active person is not able to pursue their activities, whether professional or amateur. What are the precedents involved? And there's I would call it an actuarial process, because you may be looking at a precedent that comes from 10 years ago, but money worth more now. Cost of living, the value of the money has gone down, I should say. So you look at all these factors, because it can be a very difficult exercise. One judge described it as a bit like putting your finger in the air, but it's not exactly. You're following the precedents, and you're trying to achieve that restitutio in integrum, put the patient, the litigant who's successful, back as far as money can do so in the position they were in before the operation.
And this also, I mean, one of the compensation will also include part of the general damages is actually how would one assess, as you said actually, how would one assess how much money compensation should one get based on the type of injuries? So this is where you would use similar cases. For instance, if one lost a limb, then you will use similar cases as to what award the court would have presented, whether it is 100,000, 200,000.
And as close as possible, the precedent, the case that you're going to try and use as a reference to the judge, the person is as in a similar position, of a similar age, played a similar sport or whatever it was. And in loss of enjoyment of life, if I may just touch on that very briefly, that's of particular interest. You know, I was looking at a case where a person, after an operation, they went into a coma. And there's an English authority, an English decision of a very high level. I think it was their highest court is called the House of Lords. And a young anesthetist, not long into her career, but very promising, very capable, underwent an operation herself. And because of anesthetic issues, she went into a coma. And the case was argued pro and con. The lawyer for the poor lady, her family, argued that even though she was unaware of the position she's in because of the coma, therefore it's not sad that she can't get married and have children. The lawyer for the particular hospital in England argued that, look, this person is out of it. But the court decided that even though they're not aware of the loss of enjoyment, they have suffered a loss of enjoyment. And they gave a figure, an award in pounds sterling, quite a healthy award for that loss of enjoyment of future life, even though the poor lady was not aware of it.
Yeah, and of course, no amount of money can put you back to where you were or bring back life, but of course it can provide some form of temporary comfort for unfortunate events. Of course, you can call in live 628-4578 if you have a question, if you have a comment. That is 628-4578. I'll be with Mr. Robin Otway, attorney at law. Robin, let's deal with alternative dispute resolution methods. Are there such methods available instead of having to go through litigation, which is quite expensive? What other alternative dispute ADR, as we said, can be achieved?
Yeah. Very good question, interesting question. Mediation should be your first port of call. Alternative dispute resolution can take the form of mediation normally, or arbitration. Arbitration is where you appoint a private judge and the parties to the litigation will share his expense. So that's fairly costly. Mediation is a process where you appoint an impartial person, a certified mediator, to conduct a mediation where the mediator encourages parties. What the mediator does, the basic role is to facilitate a discussion which hopefully will lead to a settlement. And mediation, I have found in my own experience, is a very positive process, much less expensive. You have to pay the mediator. The mediator's costs are shared. The mediator is not a judge. The mediator is encouraging the parties, and this normally requires them to work with the lawyers. But in my experience, sometimes the clients themselves can be the difficult ones, not always, but it's usually we lawyers who pose some problems. So you appoint a mediator and you step out of the legal world and you may go to a private office or a mediation center normally. And this mediator will sit with you and will conduct and can do so over as long as you want them to, a day, 2 days. I have done 2 medical mediations where I was not the mediator. I am a mediator myself. And one was a particularly hard case where a young man underwent an operation, very active, about 24, played rugby, played basketball, and he came out because of anesthetic issues. We contended, brain dead. And he continued to live for many years. And it was this was the first real, I've done 3 mediations. Yes, 3 medical mediations as a lawyer representing a doctor or a clinic. And in this case, with the young man, I was representing the family. And we sat with the doctors. And the first thing that happened, this was one of my first mediations, was the 3 doctors expressed remorse for what has happened. They didn't say, I'm responsible. Mrs. X and the brother, we are filled with remorse for what has happened to your son and brother. We are very sad. And that shocked me. It was a very emotional moment. And it allowed a degree, I think, of healing And there was an open discussion. This went on for 3 days, 2.5 days. And eventually we reached a settlement. Normally, I have sued doctors, I have defended doctors. Normally, when I sue them, they hate me or they don't want to see me ever again in their lives. 2 of the doctors came to me and hugged me and thanked me. I'm representing the family, I'm not the mediation. And we left as friends and with a very healthy settlement. I tell people that, I've had a long career, I've had good and bad moments, mainly good, I think. But if there's one case I will think of on my deathbed, it's that one. Mediation is highly recommended. It's a way to go about cases like that. But you will find that, mediation, a court cannot compel any party to go to mediation. If a party doesn't want to go, they can't be forced to go. And if a party doesn't want, or their lawyers don't want to settle at mediation, the mediator cannot force that. Mediator is a facilitator,
and
not a judgment maker.
And of course, it's a healthier and practical and less expensive way of dispute. And most times you find cases are settled. Of course, if mediation doesn't work, then obviously you now proceed to High Court. And of course...
Yeah, one of the positives of mediation is even me going with this family, you get to understand better the strength and weaknesses of your own client's case and the opponent's case. So it helps you even if the case has to go forward.
Now, in terms of the statute of limitation, and when we say statute of limitation, we mean how long can you take to bring an action against a doctor or a public health institution or a private health institution?
The basic period, and I can read from the particular act, is called the Limitation of Certain Actions Act, enacted, and it came into force in 1997. It's 4 years from the date, and I'm actually looking at it now, the particular section. It's 4 years from the date when the injury occurred. Excuse me a second. Yes. An action to which this section applies shall not be brought after the expiry of 4 years from A, the date on which the cause of action accrued. So take the amputation case, come out the operation, the wrong leg taken, that's immediate. The date on which the person injured first acquired knowledge of the accrual of the cause of action. So the retained objects case is relevant there. It may take you some time before you realize, okay, something went wrong during the operation. I don't know that immediately I'm coming out of the operation. And the period is extended where the person dies, the patient, let's say, dies within that 4-year period, in which case their estate, what we call a legal personal representative, executor or administrator, person representing the estate for the purposes of the law, will then bring the action, and they have a longer period because of the death. All right, and also when a person is under disability, and in the legal sense, disability could mean a child. Yeah. A child undergoes an operation. It's only when they attain majority, they become 18 years old, that the 4-year period will start to run. Or a person, a disability under a person who's not mentally well, has mental health issues, which prevents them from knowing when, look, something wrong has been done to me. And so as long as that disability exists, but of course that person would have family, normally would have some caregivers who would have a duty to try and find out what's wrong. But under disability, strictly speaking, it's when the disability ends.
Yes, and this is important to note in terms of health.
Is restored to a point where they could become reasonably so aware that something wrong has been done to me. Yeah?
And of course, in terms of someone who's disabled or someone who is a minor or an elderly, then their next friend, meaning someone can act on their behalf if they discover that they are unable to act on their own behalf.
That's a legal term that you use. Next friend, the one used by the court, a parent or caregiver could then file a case as the next friend of the infant. All right? Now, disability, of course, could mean mental disability, but physical disability, if you have a clear enough mind, physical disability won't allow the extension of that 4-year period. All right?
Now, what are some of the consequences if a healthcare professional is found? Well, I mean, in civil cases, obviously, there's consequences with respect to damages.
Yes.
Is it that an insurance? Is it that now the insurance they are every medical practice has to be insured, and the insurance companies are the ones that actually pays out those compensation?
Yes, the first part of your statement, I just lost the train of thought there, but the question of the medical insurance. Now, there are two English companies. One is well over 100 years old, what the doctors call medical defense bodies. All they deal with is medical legal matters. They're both English companies. One is called the Medical Defense Union. One is called, which is the older one, the Medical Protection Society. There may be an equivalent, I'm not sure. One of the more experienced doctors was talking to me at some time back about setting up something locally. I don't know if that's come off the ground. May have. But these are they offer coverage much more comprehensive than insurance companies do. Now, if it's a clinic or a hospital, they have to go to an insurance company. These medical defense bodies only deal with doctors, human beings, and the doctors pay a membership fee. When they complain to me that they're paying too much in membership fees, I explain to them, you should not be complaining, because with insurance, there's always a deductible. For example, in a car accident case, I crash my car, I may not be wrong, but I have to pay the first $5,000 or $15,000 of the damage. There's no deductible with the medical defense bodies. Where a lawyer, let's say, obtains professional indemnity insurance, the deductible is a very high figure. And also, you have a limit on liability. So you have a policy that's worth 3 million, 4 million, 20, whatever sum you choose. But the higher the sum, the higher the premium. There is no limit. With the medical defense bodies, it's limitless. They cover everything, including lawyers' fees, whatever award the court makes, which could be in the millions. They cover it all.
This is such an interesting area, and of course it's a very large area. But unfortunately, we are out of time, Robin. And I think we may have to do a part 2 in this particular instance. And of course, just your quick closing statements. I know Master Control is telling me wrap up. But I just want to thank you. Just a quick 30 seconds, and we are out.
Yes. This is an area that requires great care in preparation. It's expensive, it's complex, and mediation. I come back, that is a subject near and dear to my heart. Blessed are the peacemakers, they shall be called the sons of God.
Amen. Thank you so much, Robin. We do appreciate you. Be safe over there in Mexico, and we will see you again.
Be safe in Trinidad.
Yes, definitely will be. So guys, it's a wrap. You have been watching Strictly Legal on WESN Content Capital. We were speaking about medical malpractice, patients' rights, responsibilities. We'll be right back in another week. And just stay safe. You can catch our podcast, Strictly Legal with Rondell Donawa. Be safe. God bless.